Well, hello and welcome to the fifth episode of 1,000 Paths to a Career in Arbitration, complete this time with festive networking. I'm not quite sure what's going to make it festive. Does anyone have their tinsel or their holly or a small chipmunk or something nearby? Who knows? We'll find a way of making it festive anyway. For those who don't know me, I'm Mandy Lee. I'm the founder of Careers in Arbitration. We're really grateful to you all for joining us today. Now, as always, before I turn the floor over to our host with the most, time for a quick housekeeping point. We will be recording this webinar. It helps us because if we don't record the webinar, you can't watch it on video after the event. So we have to record it, I'm afraid. We therefore ask all participants to kindly make sure that their microphones and their videos are switched off during the webinar. The networking session, festive or otherwise, will not be recorded. And so you will have the opportunity to turn your cameras on and ask our speakers questions then. But for now, we want to focus on our speakers because, after all, they are why you're here. So thank you all for respecting this request. So let's move on to the main event. As always, I have the pleasure of introducing Jessica Rado, the architect and host of this fabulous webinar series. Jessica obtained her LLM from Fordham Law School, and she is a litigation associate. She's presently joining us from Italy as well. Sometimes it changes. Sometimes it's the USA. Sometimes it's somewhere else. You have to tune in to see where she's going to be this week. She's a passionate Viz-Moot coach and an active participant in numerous ADR committees and organizations, both in the US and internationally. And so, without further ado, let's get the show on the road. Jessica, the floor is yours.
Thank you, Mandy. First of all, thank you to Amanda and Careers in Arbitration for always hosting our fabulous 1,000 Paths series. Thank you so much, everyone, for being here, from our guests to our attendees, and for those who will be watching the recording in a few weeks. For those of you who are joining us only for the first time, a few words about 1,000 Paths. What this webinar series wants to do is to explore the many possible ways to pursue a career in international arbitration. We know it's very competitive. We know it's a hard field, and sometimes it feels impossible to break into it. But what we are hopefully learning from speaking with so many practitioners is that there's no need to worry. There's not just one right path to a career in arbitration, but there's actually 1,000. And so for every episode, we have two arbitration practitioners who share their experiences and they tell us how they navigated their careers so far. So for today, we have two exceptional lawyers who are going to talk to us about thinking outside the dual qualification box. In general, many of us, especially lawyers interested in arbitration, always think about becoming qualified in two different jurisdictions, either to enhance their CV or to expand the horizon of the possible jurisdictions where they can practice one day. But in general, and I'm speaking from my experience and from the people I've met, we're used to seeing a US qualification or a UK qualification as the second one. And a lot of lawyers also tend to have one qualification from civil law and one from common law. But that's not always the case. And two of the lawyers who did not go down these traditional paths are our speakers today. And I'm very, very, very happy to introduce them. And a fun fact is that, well, we generally pick a theme and then we think about the right speakers for the episode. In this case, it was the other way around. I met both Raquel and Benedict, and I was so impressed with their journey and the very, very tough bar qualifications they went through, that I just thought it was really important for us to invite them. I hope that our audience will be just as fascinated and hopefully inspired by their journey. So without further ado, I'm happy to introduce Raquel Macedo Moreira. After working in private practice for years, Raquel is now a research associate at the Center of Construction Law and Dispute Resolution at King's College in London. Raquel is dual qualified in Brazil and Italy. She holds an LLM from Université Libre de Bruxelles in Belgium, and she's now focusing on a master in contract claim and delay management in construction works at Politecnico Milano in Italy. Then we have Benedict. Benedict is a senior associate at VLG in Ottawa, Canada. He focuses on international arbitration, commercial litigation, administrative law matters, as well as a range of business and human rights issues. Benedict is an English and Ontario qualified disputes lawyer. He holds an MA from Université Paris Panthéon-Sorbonne, an LLM as well as a PhD from the European University Institute. And a super fun fact, we all speak Italian. How fun is that? All right, so first of all, thank you both for being here. We're gonna dive right into the discussion. So my first question is prompted by my curiosity, because as we said, sometimes dual qualification might be required. You might need it because you're moving to a different jurisdiction and it might be necessary, but sometimes it's just very strategically calculated. Sometimes one plans ahead, you know, you need an LLM to take the bar, so you plan ahead for years and you decide what is the best course of action for yourself. So the first thing I would like to know is, did you plan your second qualification? And if you didn't, how did you decide to pursue it? I'm gonna start with Raquel. Raquel, you went from Brazil to Italy with a stopover in Belgium for your LLM. Can you tell us how you got there?
Yes, I can, absolutely. First, I'd like to thank you, Jessica, for the invitation. I would also like to thank Mandy. I'm a big fan of careers in arbitration, of this webinar, so to be one of the people actually speaking here is fantastic. To answer your question, if I plan my second qualification, very straightforwardly, no. In the sense that I didn't leave Brazil thinking, okay, I'm going to go to Italy and qualify there and become a lawyer there. That's not what happened. I did plan to have an international career, let's say, because I liked that idea. I wanted to broaden the professional experience. But my professional choices actually were never made in an isolated context. There was also a little bit of personal aspects, convenience, and opportunity, of course. So that actually is what made me go from Brazil to study in Belgium, an opportunity to work in Italy. And then once I was in Italy, then yes, then I planned for a very long time to take this the bar exam and to qualify there. So to make the most out of my experience in Italy, yes.
She says for a very long time, as if she was, I don't know, 50 years old, 60, 70, something. Super.
Decades. It felt like decades.
What about you, Benedict? You, as an English barrister, you turned into a Canadian lawyer. What prompted you to cross the pond?
So first of all, let me echo what Raquel said, that it's a real pleasure to be here. And I'd like to thank you, Jessica, and Mandy as well for the invitation to speak. It's a real pleasure and a privilege for me to be speaking here. Again, I think planning an international career, I think that was a plan that I had. I did a bijural degree between the Université Paris and the King's College London. So I do, for my sins, have a French degree in law as well as an English one. And probably I had in mind when I was graduating something more along the lines you suggested, that maybe I would pick up a civil law qualification in France, or I would kind of come and get something like the New York bar. It didn't work out that way. Again, there's a mix of kind of personal and professional in here. When I was in Italy doing my PhD, I met a Canadian lawyer. We fell in love and got married. And while we were in London for a few years, we eventually decided to move back to Canada. And so that meant that the qualification I needed to pick up was Canadian. I've been in Ottawa ever since we arrived, and the reason for that, I like to say, there's a myth here in Canada that Queen Victoria, when she was choosing the capital of Canada, threw a dart at a map and it landed where Ottawa is. It's not true, but but like Queen Victoria, I didn't pick, although it might seem like I picked Ottawa on a whim, I didn't. My wife is Quebec qualified, and I'm obviously common law qualified, and so it was the easiest place where we could both practice in the short term when we moved, because Ottawa is right on the border with Quebec, and so it was kind of a logical place for us to go, and I've been here ever since.
Very interesting. See, he went to Italy and he found love. I mean, that's just it right there.
Yep, it's the old story.
All right. Digging a little bit deeper into your dual qualification journeys, I'm going to ask you something I think every young lawyer kind of wonders. If I move to a different country, will it be necessary for me to become qualified there? And so for you, I would like to know, was it necessary for you, Raquel, to be qualified in Italy, and for you, Benedict, in Canada? Was it your law firm that sort of like mandated it, or did it become some sort of an implicit requirement for you to have a successful career in the country? Let's start with Benedict this time.
So I think for me, it was an implicit requirement. I didn't come to Canada with a job. When I first moved here, I was still doing pieces of work through London. But because I had come through the bar, and Britain, of course, being a split profession, for those who don't know, that means that I was a courtroom lawyer, and I was instructed by law firms to do the courtroom part of representation. What that meant is I couldn't join I wasn't in a big law firm and couldn't sort of make an internal transfer from one country to another. So when I came to Canada, I didn't have a position. And it quickly became clear to me that nobody was really going to talk to me with a view to employing me until I was called to the bar. So here in Canada, here in Ontario. And so with that in mind, I had to do the requalification. There are foreign legal consultants here in Canada. I know a couple of them. All of the ones that I know are also qualified here. So I've heard of very few people who sort of make a successful career out of being purely a foreign legal consultant and just advising Canadian clients on the law of a foreign jurisdiction. So I think the reality here is that most firms will either want you to be qualified already if you're not already with them, and even if you are sort of making an international transfer within the same firm, most of them will ask you to requalify when you get here as quickly as you can.
What about you, Raquel? What was your experience?
I'd like to say that generally speaking, it really depends on what type of work you're doing, because with my experience in Italy, it wasn't necessary in the sense that nobody told me to get that qualification. When I arrived, I was lucky enough to find a job at a great place, a place that I loved. And I was working with international arbitration most of the time. So I was already qualified in Brazil. There wasn't this need. Nobody pressured me into doing this. But, and I'm going to be very candid here, there was one pressing issue, which was taxes. So as a lawyer qualified only outside of the European Union, I couldn't register to the Italian bar as a lawyer, which means I couldn't have access to the so-called Cassa Forense, which is like the social security for Italian lawyers. And I was in this leftover category that paid a lot more taxes. So to be very honest, this was the first thing that made me think, should I consider becoming a lawyer in Italy so I can pay less taxes? And then after I started working, and even though it was international arbitration, many of our clients were Italian and we were discussing things in Italian. There were always parallels to Italian law. So at one point, it just made commercial sense, because even though it wasn't necessary, it definitely increased my profile. It helped with credibility. Whether you want it or not, when you tell someone, but I am a lawyer qualified also in Italy, to an Italian, that has some weight, because they know how the bar exam is difficult. So that actually adds to your, it helps you fit in more evenly. So that was definitely something that I took into account. But then again, now that I am based in London, a lot of people have asked me, okay, so do you want a third qualification? Are you going to qualify also in the UK? So the first reaction is no, I think I am good with this. But I don't really need one. The environment is much more international. So there is room, for example, for what Benedict was saying, for a foreign consultant. So it really depends on where you're going and what you're doing, I would say.
Very interesting to see the two different experiences, and also super fun to hear, dual qualification as a way to pay less taxes. It's terrific. But I don't struggle. So So I'm curious to learn a little bit more about what the dual the process to qualify was. In particular, let's start with Raquel. Did you need to complete additional degrees or other coursework in order to take the bar in Italy?
I did not. I needed to do an exam, but I didn't need to make any specific courses to be able to take the exam. I don't know. I see some familiar names here, and I know that they are familiar also with the qualification process in Italy. But for those who aren't, trust me when I say that Italy has bureaucracy that would make many countries confused, and it's a very difficult thing to do. So the bureaucracy is very hard. I had to had an enormous amount of documents translated from Portuguese because my original university degree is from Brazil, so in Portuguese. I had to translate all of those documents to Italian, and documents that went back to high school records. I sent everything to the Ministry of Justice. They look at it and they say, okay, based on what you have studied, you need to complete test A, B, C, and D. In my case, they gave me all of the exams, which meant 3 written exams and 6 oral exams. In the middle of everything, COVID hit. So it was a very lengthy process. I was also working full time, so I would study in the evenings, during weekends. I bought the books and I was studying on my own. It took me roughly 3 years from start to finish, from the moment that I began with all of the translations to the moment I passed the exam, but with the satisfaction of a lifetime, definitely.
I can imagine. It's a triumph for Italians to pass the Italian, but I can only imagine for a Brazilian lawyer. I can only imagine. And what about you, Benedict? What was your process to qualify in Canada?
So there's a 2-step process in Canada. There's the first step is the same no matter which province you're applying to, except for Quebec. It's called the NCA process, which is the snappily titled National Committee on Accreditation. That sounds kind of similar to Italy in that it's a series of self-study exams. There are courses you can take and pay for that help prepare you for those, but they're not mandatory. You don't need to take them. In my case, I just studied for those myself, and kind of before you can even sit those exams, there's an assessment of your file that takes place by the NCA, similar to the Ministry of Justice in Italy. So they take a look at your university education, your experience, and tell you which exams you have to sit. I was lucky. There are 12 exams. I only had to sit 5 of them. They considered a lot of the kind of substantive common law courses that I would have had to have taken to be equivalent for my British qualification. So I just had to sit what are called the 4 mandatory exams that everybody sits, which is administrative, constitutional, criminal, and Aboriginal law. And then I also had to do an exam on corporations because they considered this what I'd studied wasn't sufficient there. So I studied for those myself. It similarly to Raquel, it took some time. I took my first exam when I was still in London in 2014, and then I sat the rest over the course of early 2015. I think I sat the last one in summer 2015. Then the second stage, having completed that, you get a certificate. You then submit that to the provincial bar that you want to qualify for, in my case, Ontario. They reassess your file. That takes time. And then you sit the bar. And so for me, that was spring of 2016, which shows you kind of how some of the delay that's built into the process. It took a good 8 months between finishing the NCA exams and actually sitting the bar exam. And then after that, if you are exempted from articling, so from a traineeship as I was, which is part of the assessment that the provincial bar does, then you have to sit a short course on professional responsibility, and that was offered in the summer. So then I took that in the summer of 2016 and was finally called in June 2016. So I think from start to finish, it took 2 years. It was longer than I had thought when I first kind of looked at, oh, well, here are the steps in this process. I can bunch up a bunch of exams together. I can get those done quickly. Then it'll just be a simple question of the bar saying, yes, you're ready to go, sign up for the bar exams and we'll exempt you. It wasn't. It took a lot longer. There's a lot of kind of inherent delays built into the process. Some exams are only offered at certain times of year. The time for assessing your file and marking exams, that's quite slow, things like that. So it took a good 2 years, and I certainly know people I've spoken to here in Canada for whom it's taken even longer, especially when they're sitting all 12 exams.
They both sound very rough processes that you guys had to go through.
Jessica, can I just add one thing? Because I think
Yeah.
it's important to say it all looks very successful now that we talk about it. But the truth is that, for example, in my case, it also took very long because the first time I took it, I didn't pass. So you also have to factor that into account. At the moment you don't pass one of the exams, you have the choice. Should I try it again, or should I just, leave it as it is? So it's also it's a constant test on your persistence and how much you want that. Yes. Looking back, it's so much easier to say, oh, 3 years, but
Yeah.
What 3
Yeah,
years?
I totally echo that. And I think if you have more than sort of the four exams here, if you have the whole panoply of them, it's a good idea to consider whether one of those courses that prepares you for them is worthwhile, because otherwise studying for 12 exams, especially if you're coming from a civil law background and this is the first time you're dealing with kind of a Canadian, Australian, British common law type system, that's a challenge to do by yourself.
Yeah. Well, that kind of ties into my next question. I'm going to start again with you, Benedict. Qualifying into civil law and common law systems, I'm curious to see what difficulties and what difficulties you found and what helped you. In your case, you sort of like mentioned this already. Coming from a common law jurisdiction, for example, you were exempted from some of those exams. But I'm wondering if, when you were actually sitting for the bar for these exams, if the study you had to do for those exams and the test that you had to pass, did your previous common law qualification help you, or are they still two different processes, and so it doesn't really help you in any way?
I'd say the answer to that question is yes and no for me. As I've kind of already said, my existing qualification from England, and I say England rather than the UK because, of course, Scotland is a mixed civil law system that's separate to England and Wales. But I was exempted from however many it was, 7 out of the 12 exams, because I didn't have to sit those at all. So that in that sense, my existing common law qualification certainly helped me. I think, funnily enough, in practice, I think, especially when I was here in my early years, there were a lot of times when I sort of had to check my assumptions at the door, where I would assume that things would be the same in Canadian common law as they were in English common law, and I would find that assumption to be wrong. There are a number of ways that the legal systems have grown apart, even though they're closely related. And so I think that's something that's important for people to sort of realize whenever they're going through a dual qualification. You might think that the systems are superficially similar, and they are superficially similar, but they're not. You find that they have some quite wide differences. Quebec is a perfect example of that. I know a number of French. There's a very easy cross qualification process from France to Quebec and vice versa. If you're qualified in France, you basically get a complete exemption to be called to the bar in Quebec, except for a déontologie, so a professional ethics process. And there are a number of, I've spoken to kind of a number of French advocates who come across and then are really surprised at how different the Quebec system is. And that's because a lot of the procedural aspects of the Quebec system are really English common law inspired. The way that judges are appointed, the way that the civil procedure works, a lot of that is quite different. And then there's a lot of kind of hybrid parts of the Quebec system that differ from kind of a classic civil law system like France. Sorry, that was a kind of a long answer to your question, but so I think the real strength of any dual qualification process, whether it's from a common law and to another common law jurisdiction, or whether it's from a civil to a common law or vice versa, I think the real strength you gain through the process, long and arduous as it is that you kind of gain a real comparative viewpoint, which is a real strength as a lawyer. I think we you know, you can, when you finally come out of the end of this process, you have an advantage over some of your peers, because you've lived some alternative solutions to legal problems that they don't necessarily even see, because they've only lived with kind of one view of the legal reality their entire professional life, whereas you may have seen two different ways of approaching particular problems. So I think that kind of comparative viewpoint, even between different common law systems or different civil law systems, can be a real strength.
Well, it might have been a long answer, but I learned so many things that I didn't know. So it was really, really interesting. Same question for Raquel. You had already a civil law qualification, and you then took a second one. Do you think being qualified in Brazil helped you a lot at all in Italy, or do you think the two systems are just too different?
No, I think it certainly helped on many different levels, actually. The first one was the fact that when I took the Italian bar exam, I was older. I was more experienced. I understood better how to think in terms of a legal perspective, so that definitely helped. I think that really made things just simpler than what I thought they looked like when I first took my bar exam in Brazil. Another aspect that helped is that Brazilian law and Italian law, very generally speaking, come from Roman law, which is actually something that I studied for a year in my university in Brazil. So that definitely helped. The bases were the same. The way that the system is structured is the same. The codes are kind of structured the same. So that really helped. For me, the hardest parts from which I really couldn't transpose anything from the Brazilian experience to the Italian experience were procedure. Procedure was really hard for me, especially criminal procedure, because it was something that I didn't see on a day-to-day basis. And so I had no idea what was happening. And the second one was vocabulary. So for me, taking a different bar exam meant doing it in a completely different language. And for you to have an idea, when I first moved to Italy, which was July 2017, I didn't speak Italian. Still, Italian is kind of similar to Portuguese. And I was completely immersed in an Italian context, which really helped me understand. But from July 2017, when I didn't speak Italian, to the first written exam that I took, which was March 2019, so a little less than 2 years, I had to figure it out how to not only speak Italian, but write it in a way that worked for the exam. And well, you both speak Italian, so you're going to understand me when I say that this thing about double letters in Italian, for me, was a struggle. So for those who are listening and do not speak Italian, many words in Italian have double letters. And there isn't a specific grammatic rule for it. People say, you can hear it when they are speaking. Well, I can't. So I had to guess most of times. And I was working at the time at a law firm with an incredible team. So what I would do, especially after I didn't pass the first written exam, I would write these samples and I would distribute them at the office in my team. They would correct both the substance, so the legal part, as well as what I was writing to see if the Italian was okay. So that helped me a lot. I was very lucky to be able to count on them during that phase. And so all that to say that a few things helped, a few things were completely different. But then again, going back to the first thing that I mentioned, once you have already gone through a process like this, you kind of feel more prepared even to deal with something that is unexpected.
I'm sorry, I just have to stress this because I need everybody to let this sink in for a second. So she did not speak Italian, right? She learns Italian. In 2 years, she sits for a bar exam. And just so you know, the Italian bar exam is not, I speak for the New York one, knowing that one. It's not multiple choice questions or like very short sentences. You need to write as a lawyer in Italian, which, you know, Italian lawyers are notoriously writing very, very long and complex sentences. And it's just like unbelievable to me. So just want that to sink in for everybody, you know, it's a huge achievement. So really kudos to you again, Raquel, because that's amazing, honestly.
But one day, just for fun, I'm gonna show you the first sample that I did, and we're gonna laugh about it because it's just a disaster. I've gone a long way. There has been a lot of help.
Well, it's still terrific, really, truly. All right. I'm gonna now ask you something kind of similar, but more focused on your practical experience. Oftentimes, when that second qualification is sort of planned and very strategically picked, it then, you know, it's sort of like achieved and archived, I'd say. You know, you take the bar somewhere else where you went for your LLM, and then it sort of like stays on your CV, but you don't really practice in that second jurisdiction. That's again not the case for either of you, because you have practiced extensively, Benedict in the UK and in Canada, and Raquel in Brazil and Italy. So I'm kind of curious to know what differences you've seen in the two systems for a professional point of view working there. And I'm wondering if there's something that you miss from practicing in your home country. What about you, Raquel?
Well, technically speaking, I didn't get to practice as a lawyer that much in Brazil. What happens in Brazil is that you usually work during the university. So I worked from the second year of university, which means that I worked for 4 years before I became a lawyer. And then after I qualified, 3 months, and I was out of the country. I think that one of the things that I miss the most about it is not feeling alone in my career path. I don't know if that makes sense. When I was working in Brazil as an intern, I worked in law firms, and I felt that I was surrounded by people that were doing the same thing as I was. So everybody knew where they were going. Everybody was, you know, it's so much easier to compare yourself to other people, and it gave me kind of an assurance that I was doing something right when I saw that other people were doing the same thing. Once I started working in Italy, the first thing that I did was second guess everything that I did, because I didn't have that basis for comparison. So it took a lot of work also to get out of that comparison habit and understand that just what I'm doing is different from what most of the people I see in the same place that I am. It's different from what they are doing. So it has been harder to relate to other people's experiences, to share obstacles, to ask for advice. So that is something that is definitely something that I miss. But I understand that it's the price you pay for doing something else, that at least in my case, the benefits have been much more rewarding than how much these difficulties have bothered me.
And what about you, Benedict?
So what Raquel just said is something I hadn't sort of prepared for my answer, but I totally echo it. It's definitely a lonely process when you kind of when you're requalifying in what's not your kind of home jurisdiction, where you've probably gone through that process, that path to qualification with a lot of peers around you. And yes, finding your own kind of grit and determination to finish the process, I think, is a key thing. The other thing I would say is kind of on a more hopeful note is that I've seen things open up a lot in Canada in recent years. One of the things that I do is I kind of connect with internationally trained lawyers who are requalifying here, and I've had a lot of kind of coffees and virtual coffees with those people, and I do see that the profession is opening up a bit now in this decade compared to my experience kind of in the middle of the last decade, when it was still a little bit more close-minded. But in terms of sort of my kind of the biggest differences I've noticed and what I miss, those are both related to litigation, which is kind of interesting given that we're on an arbitration webinar. But the biggest difference I find is the approach to kind of discovery and to witnesses. So in the UK, there's no examination for discovery like there is in Canada and like there is in the US. Disclosure, as it's called in civil trials, is document-based process only. You don't get to examine people as part of that. And there's not even examinations in chief or direct examinations in many civil trials anymore. There are exceptions to that. Defamation, famously, of course, is one of them with the Johnny Depp trial that happened in Britain not so long ago. But most of the cases I was doing when I was a young junior barrister in London, I didn't get to examine my witnesses in chief at all. And I never examined someone for discovery. I came across to Canada and suddenly I'm sort of examining witnesses in that way pretty frequently in my litigation practice. And again, sort of depositions and things, that's something that is in theory available in England, but it's very, very rarely used. It tends to be used if a witness is sick or very, very old and can't make it to the court. And otherwise, it's not a widely used thing. So it means that you examine witnesses less. And when you do, you're usually in front of a judge. So it encourages lawyers, I think, to be very careful with making objections. I tend to find British barristers are much less interventionist when it comes to objecting to questions in front of witnesses, whereas here, especially when you're out of court, you can have a bit of a lawyer battle in the examination room. But this does bring things back to arbitration, because one of the things I found was, right, of course, in arbitration, we often don't have examinations for discovery or even a discovery process as it's understood in the US and Canada. We often have a more restrained process. And we often dispense with examinations in chief. We just put in witness statements and take them as read. So for me, when I'm talking to my colleagues about arbitrations, I'm coming from a space where I already understood that, because that was something I was already familiar with from English civil litigation. So that's probably the biggest difference I found. The thing I miss is the split profession. It's kind of a selfish thing that I miss. It's for two reasons. One, I enjoyed being self-employed. I think I'm just a bit of a maverick. I don't fit into sort of the employee straitjacket as well as other people. So I miss that kind of control over my own career that I had as a self-employed barrister in chambers. But the other thing I think is I miss the vanishing I miss the opportunity to be in court or in hearings from an arbitration perspective more often. So the advantage of a split profession is, because you're the court lawyer and you're only sort of instructed at the sharp end of disputes practice, you're in court much more often. Here I find in Canada, the vanishing trial, the vanishing merits hearing, it's a real phenomenon, right? I mean, I have lots of files, but very, very few of them go forward to a trial or even get close to it. So in the UK, I was just in court much more often than I have been since I came to Canada, and I think that's something that applies across different areas of the law, whether you're doing kind of family law or commercial law. So that's certainly something I miss, and I do think it brings advantages, because as a young lawyer, you get the opportunity to hone your advocacy skills much more than I think you do at the early stages of a fused profession.
Lots to think about there. Thank you. I'm gonna go back to you, Benedict, right away with the next question. I'm gonna divert from the dual qualification topic for a second, just because I'm a little bit curious to know a little bit more of your personal practices, what you focus on in your everyday professional life. And for you, Benedict, I would like to know if you can tell us a bit more about human rights issues. I know that you are primarily a disputes lawyer, but you also focus on business law and human rights. And I'm curious to see how these two, how arbitration and business can intertwine with human rights in your everyday practice.
For sure. So I have a mixed practice, which I think is a common experience here in Canada. We're a smaller jurisdiction. There are people who have exclusively arbitration-based practices. They tend to be at the senior end of the profession. So mine is a mix of litigation and arbitration. When it comes to arbitration, I've tended to focus more on investor-state disputes, but I do some commercial work as well. And I've had a number of cases involving mining and other extractive projects, as well as some construction and more run-of-the-mill contractual disputes. When it comes to human rights, I always find this is a really interesting question. And here I'm going to get up on my hobby horse and tell you all about my vision for the future. I do find that human rights are becoming more relevant to the practice of arbitration, particularly to investor-state arbitration, with kind of the increasing discussion of social license issues in investor-state cases and the rise in counterclaims by states, which are usually brought on environmental or human rights grounds. So increasingly in my investor state cases, we're having kind of a battle of the impact assessments where you have states or NGOs doing an environmental or a human rights study and an investor in a project doing their own study. And so you may end up one of key evidence before the tribunal when you're arguing something like fair and equitable treatment may be whose study is more valid, or what important principles can be drawn from the various studies the different parties have done about this project that's under the spotlight. And so kind of understanding some of those human rights study methodologies, things like ACWICON, the methodology of the Danish Institute of Human Rights, that's becoming a distinct advantage in this field, I think. The other thing I think is that we're just increasingly shining a spotlight on human rights due diligence across the spectrum. We've got transparency legislation of various types emerging and moving forward across the world. And a key issue in that space of the last 5 years has been remedy. What remedies business offers people for human rights issues when they come up, and operational grievance mechanisms, which were kind of the popular solution in 2010 or thereabouts, often just don't cut it. They either end up being criticized for being overly formal or too expensive, or they don't exist at all. And on the other hand, when really kind of big problems come up or disasters happen, like the Rana Plaza collapse in Bangladesh, we're seeing a growth in ADR in that space. So the Rana Plaza Accord has an ADR process for resolving disputes that arise under it. I don't think it's been ever used, but the mechanism exists. So I think there's actually a big opportunity for kind of business and human rights arbitration. And I put those two words together because I think it's distinct from sort of human rights dispute resolution. It's distinct from commercial arbitration. But I think there's an opportunity for business and human rights disputes to be arbitrated and to take the place of some of those expensive or failed grievance mechanisms, or to take the place of kind of protracted courtroom litigation. So I really think there's a business case for it as well on the business side, if people would just kind of wake up and educate themselves about some of the rule sets that have been developed, like the Hague Rules. I think there's some real advantages to kind of plaintiffs as well, that there's an opportunity to avoid very, very long protracted court battles through traditional kind of class action mechanisms and things like that. So, and then finally, I told you I was getting on my hobby horse. I think it's a potential answer to the crisis of legitimacy in international arbitration. I don't want to sell kind of human rights arbitration processes as a panacea, but we have had in recent years a crisis of legitimacy in investor-state dispute resolution, with people criticizing it for being closed and overly confidential, not transparent enough, keeping stakeholders out of the process, things like that. Well, here's an opportunity to bring some of those stakeholders back in through an ADR process, and see how arbitration might actually work for them, and avoid some of the problems that we see, as I say, with traditional litigation. So I could talk about this for a long time, but I think I'll stop there. That's my 2 pennyworth.
I was just thinking we need to invite you back for another episode, and we need to talk about this only. There's just so much to talk about, but that's very, very interesting. And thank you for sharing at least, a part of it and an introduction to this, to what you do, which is truly interesting. And I do hope we get to learn more at some point. Sort of a similar question for Raquel. Raquel, you have been focusing a big part of your career on construction law. And I'm curious to hear your experience and to learn how it's been for you to wear so many hats when focusing on the same field, because you've been studying construction law. We mentioned you were doing a master's focusing solely on construction law. You've been counsel, you've acted as counsel in construction law disputes, and now in your new role at King's College, you're doing research on construction law. So I'm wondering what you learn, what you see, and what you love about wearing all these different hats when focusing on it.
Well, let me start by saying that I actually like construction, which I think should not be a granted premise, because I have heard a lot of people speak ill of construction, and I actually find it fun. So that has been a nice thing going on for me. The thing is that I didn't actually choose construction. I have the feeling that construction arbitration more sort of chose me. One of the best advice, in my opinion, that I had when I was starting to work with arbitration was actually more than one senior practitioner told me you should choose a substance portion of the law to specialize in, because I had always known that I loved arbitration and that I wanted to work with it. But then they told me arbitration is a procedure. When someone is going to call you to represent them or to be an arbitrator or in any capacity in relation to an arbitration, they want to know that you also have the expertise. So I got thinking, okay, I should choose an expertise. What am I going to choose? What do I like? And then while I was working in Milan for the first 4 to 5 years, I think that 90% of my arbitration cases were construction. So I didn't really had a choice. I had to specialize in it. So it started actually as counsel. I saw from a practical perspective what the client wanted. I had to learn different construction processes for each of the cases that I worked on. And I found that it was really interesting. I felt though that I was missing the understanding of the theoretical part. So a delay analysis. What is a delay analysis? What are the ways in which I can analyze delay in a dispute? So those kind of thoughts were the main driver for going to study the theoretical part. And then it definitely helped. There were some exchanges in the sense that studying the theoretical part made me feel like I was a better counsel, and being a counsel made me feel like I was a better student, because I had questions that arose from a very practical perspective. And now as a researcher, I actually feel the same thing. We are working, for example, on a very big project, an empirical study for the dispute resolution in the construction sector, and just to know what questions to ask, to know what is the reality of the sector, to understand what is the perspective of the parties. So I am a big fan of bringing different perspectives into the table, and much like the idea that Benedict mentioned before of having two qualifications is something that it's actually works to an advantage, because you know things that, and you see things interrelations that people don't necessarily don't when they are inserted in one single context. So these different hats have definitely, at least in my opinion, enriched my experience as a counsel, as a researcher, as a student. So I'm a big fan of their approach, and then well, construction it just became my expertise by almost by chance.
It's funny, we hear it so many times. It's not that, arbitration or this field, or I chose the arbitration or this field. It chose me. We hear it a lot in arbitration, honestly. It seems to be a recurring theme. Okay, we're almost done. I have just 2 final questions for you, circling back again on your dual qualification journeys. Raquel, knowing what you know now, is there anything that you do differently if you were to go back? And would you use a different strategy to obtain your second bar admission?
I think that's a very hard question to answer, because with the head that I have right now, I can definitely think of things that I might have chosen to do differently. But I consciously choose not to go down that road, because I like the idea that I did the best I could while I was doing it, and that standard is fine for me. So I'm just gonna stop at that. I think I'm satisfied with how things went, because I am really convinced that I did the best that I could.
And what about you, Benedict?
Yeah, I think Like Raquel, I'm pretty content with where I've ended up. I mean, I think if I was to change one thing, I might have, knowing what I know now, I might have tried to reduce kind of the delay once I landed in Canada by either trying to join a law firm in Britain and then making a transfer that way, so that I would kind of do an internal transfer, and then that would have made for a smoother transition over here because I could have been working while I requalified, or I would have sort of made an effort to sit more of the initial exams in London, and just get as much out of the way before kind of coming across the pond. I think both of those things. Otherwise, you definitely have kind of a lonely 12 to 18 months while you're sitting around waiting for things to happen that you have no control over.
That makes sense. And finally, one last question. I'm going to start with you again, Benedict. What advice would you give young practitioners looking to become dual qualified attorneys?
I'd say be tenacious and be realistic with yourself. If you've already, I mean, I echo what I said before. If you've already practiced in another jurisdiction, you bring a unique perspective that nobody else has, because you see things that other people don't necessarily. You have a different view, you have a different cultural perspective, you have a different legal cultural perspective, and you have a different kind of legal perspective. All of those things are true, and they can be a real advantage. And I think people need to take more. People need to sort of recognize that strength that internationally trained lawyers have. But that's also something that's worth fighting for. And the reality, at least that I've found, is that you will encounter kind of prejudice and closed-mindedness along the way of people saying, well, why didn't you qualify here? Why don't you have, X experience in this jurisdiction, et cetera, et cetera. So it's a lonely path and a difficult path at times. Kind of requalifying again, kind of as Raquel said, you don't do it with your peers, and you don't sort of go through university with all the people who are doing the same thing. So in that sense, you need to rely on yourself much more. And so some tenacity is definitely something. It's a quality I think you need to cultivate. And I think in terms of being realistic, it means knowing when to push back and to sort of know when the fight is already lost, so that you're fighting the battles you can win, in terms of targeting the law firms or the places of employment that are open-minded and going to be receptive to you, or in terms of just knowing, looking at the cost-benefit analysis of how long this is going to take and how much it's going to cost you to requalify, and at what point are you going to sort of draw the line. I think those are important things to have. You do need to be realistic with yourself about when to stop. And then maybe kind of my cheeky piece of advice is develop a practice in arbitration, because it's one of the most international and portable areas to practice in, right? It's an easy one. It's an easy sell when you come across to another jurisdiction, because you can kind of start working in it right away. You can say, I'm doing arbitration already. I can continue doing arbitration while I'm here, and while I requalify, please employ me. So 1,000 paths to arbitration is the right place to discuss dual qualification, because I think arbitration is one of the most portable international practices out there.
That's terrific. And what about you, Raquel? What's your advice for young attorneys?
I would say it's actually something that I tell myself very often when I'm giving myself advice. So it's kind of a two-part thing. So the first one is to have a plan, because having a plan brings, I believe, consistency and direction to your efforts. So it concentrates your energy into something. So I am a really big fan of plans. If I could, I would plan absolutely everything. But then the second part is be ready to change the plan, because the plan very rarely goes exactly as intended. And very often in the middle of the plan, even if it's going well, different opportunities present. And I think that being able to embrace those opportunities and to consider a different path, I think it's something that is very, very valuable. I think it's a great skill. On one level, I agree with Benedict when you say that it's important to be realistic, but at the same time, I am a really big dreamer. So I have this impossible goals and ideas. And I think that I would adapt the realistic view in the sense that I would say it's important to be realistic. When a certain path is not working, maybe don't quit, because when you quit, then you lose. It's a certain thing. So if you don't quit, you haven't lost yet. I believe in that. But then try to find different ways to achieve that thing that you want. Because insisting on the same way when that way is not working, it doesn't really make any sense. But to try new things, to try different things, to connect with people that have done what you're trying to do. I think that is also something that I would say is advice, because I have as a rule not to ask advice to someone that hasn't done what I am trying to do. So to find people that have actually done specifically the dual qualification that you're trying to do, and see what they have to say, because they have gone through it. They know the practical aspects of it. Yes, that's the advice I would give.
Terrific. Well, thank you both so much. We are done with our discussion, and I'm sorry we're a little bit over time. Before we move on to the Q&A, I'd like to thank you both for sharing your experiences and for walking us through your incredible career journeys. As we mentioned at the beginning of the webinar, the networking session will not be recorded, so this completes our program. I am happy to leave the floor to Amanda Lee for closing remarks, and then we'll move over to the networking.
Well, let me just echo Jess in saying thank you very much to our fabulous speakers for sharing their insights with us across the miles. Those are some challenging journeys that you have both embarked upon. My dual qualification seems quite laid back in comparison, mindful that I don't think the MBE is in another language, even though it might feel as if it's in another language sometimes. So very, very impressive. Thank you all so much for joining us. This is the 5th episode of this fabulous show, which, as I often say, was entirely the brainchild of Jess. So I am extremely grateful to her for all her hard work and all of the preparation that goes into this behind the scenes, so I can show up and make a couple of bad jokes at the beginning, and then I can hand the floor over to her. So we must all be very grateful to her if we're enjoying this show. So thank you, everybody. For those who are embracing the holiday season, this is going to be a festive edition of our networking, which means we'll all be a little bit jollier than usual, because, the holidays are coming soon. So thank you all so much, and we will see you once again in 2024. Bye for now.